It is June 16th of 2026, and this is the Court Gallery. Today, we're taking a tour through multiple courtrooms with wildly different judges. First, Judge Cooper presides over small claims where a runaway shopping cart is on trial. But the mood shifts dramatically in Judge Oakley's court when a defendant's bad attitude earns her contempt charge and a trip to jail, all for asking for an expungement. Then, Judge Mcnally has absolutely no time for a defendant who lies to her own lawyer, telling her to save the lies for some other judge. And finally, the session climaxes in Judge Simpson's court, where we'll see Bodycam footage of a man high on nitrous, fighting police, and riding the lightning. All this and more starts right now.
All right, next is Lewis Perry versus Menards.
Yes, sir.
All right, you are Lewis Perry, is that correct?
Yes, sir.
All right, is there somebody here from Menards? Okay, sir, could you tell me your name?
Andrew Lewis, Your Honor.
I'm sorry, say that again, please.
Andrew Lewis.
Andrew Lewis, all right. And you are here on behalf of Menards, is that correct?
I am, Your Honor.
All right, we'll start this case in just a second. Here's, was there? All right, Mr. Lewis, and I don't, this is the trouble when you're dealing with a larger company. Did you get any information about going to mediation?
Yes, sir. And according to mediation, they advised me
Okay,
that.
I got that, Mr. Perry. I'm aware that you were there. I'm asking Mr. Lewis.
Oh, sorry. His last name is
That's
my
all.
first name. I got confused.
Oh, all right, sure. Sorry, I see the confusion. All right, Mr. Lewis.
Yes, Your Honor. I was actually advised by my legal counsel not to mediate. Okay,
all right, that's fine. We'll go ahead with the trial. Then I'd ask you both to raise your right hands. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, so here's how these work. You guys can put your hands down. I'll hear from Mr. Lewis. I'm sorry, from Mr. Perry first. Then I'll hear from Mr. Lewis. And if I have any questions, I will do that. I'd ask that neither of you interrupt the other. You'll each get a chance to speak, of course. So, Mr. Perry, starting with you, what is the basis of your claim?
The basis of my claim, Your Honor, is that Menards was negligent in retaining their carts in the proper prescribed manner per their policy procedure, which led to the cause of damaging to my vehicle and almost $2,000. I have documentation to share to show you. Apparently, I could only show it in chat. I'm not sure how that works. I've never really quite done this with Zoom before.
All right, tell me what happened. I'm reading your complaint, but tell me what happened.
Yeah, I was approached by two managers from Menards and asked if I owned a gray Cherokee, and I said yes. The one manager made that he said that he saw a cart that was leaning against the driver's side of my door, and that him and the other manager went and reviewed the tapes and saw that the cart by itself, without the help of any human intervention, left the cart barn, went about halfway through the parking lot, and made impact with my driver's side door, causing me almost $1,900 in damage for the repairs.
All right. And so you spoke to somebody from Menards at that time, you said?
Yes, I did. I even have a statement from that manager that I could share as well. They made a claim for me. They went through a third-party company that they used to hear all their claims that are made against them for loss. It was denied by them within 48 hours. I then appealed that with documentation and pictures. Within less than 24 hours, they denied me again. Then since learned that the company of Gallagher Bassett is not their insurance company, that Menards is self-insured, that's just a clearinghouse for them that handles their calls for claims. And that is why I brought my suit against Menards itself.
Okay, you did not witness this happen, but you saw a videotape of it?
No,
Is that
sir,
what
they
you said?
refused to share the videotape with me. They refused to show the videotape with me. And when I asked if I could see the videotape, I was told, quote unquote, subpoena it.
All right. Okay, all right, thank you. So, Mr. Lewis, what did you want to, well, first of all, let me ask you one more question, Mr. Perry.
Yes,
This
sir.
took place at Gaylord Menards?
Yes, sir. I also have documentation here from their policy procedures that indicates what's supposed to be in place in those units to prevent this from happening. I have pictures showing that those were not in place to prevent it from happening. And then
What is supposed to be in place?
according to their policy procedure, they're supposed to install on both ends of their cart corrals the use of a tiled transition strip on both ends of the corral to reduce the number of carts that can leave the corral. I also have a copy of their diagram showing the construction of the corral. That's also supposed to show a bar in the back of the corral. That's also not in place. Once this was kind of brought to their attention that this was happening, ironically enough, the day that corporate was coming from Wisconsin to visit the store, the thresholds are now on the ground.
I'm sorry,
Also,
what was the last thing you said? That the day that corporate was coming to visit, what was next?
they now have thresholds in the cart barns.
Okay, all right, but at the time of the incident, there was no strips and no bar?
That's correct, sir.
Okay, all right. Okay, all right, thank you. Mr. Lewis, what did you want to say?
Yes, Your Honor, thank you. I'd first like to start off, just to say, I'm sorry that we're even in this situation. There's no reason that we ever want any kind of animosity between ourselves and our employees. We really pride ourselves in trying to provide a really good work environment. I'd like to just say that I believe, we take reasonable steps to prevent this from happening. We have dedicated employees just for carts. We have cart valves provided for the guests to be able to put away carts. We're fined by our own company if we actually do not get the carts out of there in a timely manner or have over the amount. We provide limited amounts of carts. We're not Walmart. We don't have over 1,000 carts. We do this so there's not a saturation inside of it and it can be handled. Also, we do provide employee parking for all of our employees that's in the perimeter of our parking lot to help avoid these kinds of issues away from our cart corrals. Unfortunately, Your Honor, it was a windy day. I've reviewed all the footage. A customer put away the cart. They did push it a little bit harder. It seems it may have bounced off a cart that was in there. There was only one other cart in there. And then when the wind caught it, it did take it directly into Mr. Perry's vehicle. Unfortunately, Mr. Perry on this particular day did decide to be rather selfish. He decided he did not want to park in employee parking, that he wanted to park in our customer parking. And had he have actually parked in employee parking, I believe this entire thing would have been avoided.
All right, I did not gather this, but Mr. Perry, were you an employee of Menards on that date?
Yes, sir.
All right. Was what he said accurate?
Yes, sir. There wasn't any employee parking that I saw available, so I parked at the furthest point in the last parking spot that was available in the parking lot on that day.
All right, asking Mr. Lewis now, Mr. Lewis, is it a requirement for employee parking that they park in employee parking, or is that just a suggestion for lack of a better term?
It is a requirement, Your Honor.
Okay.
And there were several spaces of open, and he was nowhere near the furthest he could have been.
All right. Were the strips and bar that he was referring to, were they there as of the date of the incident?
So at our particular location, we can't even use the transition strips due to heavy winds. We do not employ them in the winter, and we still hadn't received our cleaning. We do have actual half-inch rebar in place because even with tile strips, they've been popping out of there. But once again, like I said, I believe that we've put reasonable effort forward to make sure that we can try to avoid this. Unfortunately, I believe we all take some kind of responsibility anytime we get into a parking lot, whether it be from other vehicles or cars. I mean, this is why we do insure our vehicles.
All right. Mr. Perry, I'm assuming you no longer work for Menards. Is that true?
No, sir. I'm still employed there, and if I may kind of piggyback on the statement he just made there, I could understand if I was the first person or the second person that was filing a claim against Menards for this incident, for an incident such as this with their carts. I was advised I was between the 8th and 10th person that filed the claim for the carts.
I can't get into that. I have to look at this on its own merits.
Yeah. Well, I was just saying it, Your Honor, because they're saying they take diligence to try to prevent these things, and they didn't.
I understand, and we get a little informal. This is small claims court and not a general civil case, and it's in small claims because the amount isn't huge, as those things go. All right. All right. Well, here's what I'm going to do on this. The claim was for $3,000. I do find that Mr. Perry should have parked in employee parking, or at least closer to it. But I don't know that would have made a difference. That's pretty clear. But yet, on the other hand, Menards should do something more, at least in my opinion, based on this. And this isn't legally binding on anything other than this case. But I do find they should have done something more. So I'm going to split the difference. And the judgment will be for $1,500, and plus court costs. So it'll be there's $105.79 in court costs. So it'll be 1,605.79. And I have signed that judgment. A copy will be mailed out. Mr. Lewis, and I know you meant nothing by this, but when there's a mediation, it wasn't framed as an order, and I'm just a magistrate. These are Judge Hessling's basically orders that go to mediation. I understand your attorney said, hey, don't do it. I'm an attorney. Probably if I'd been there, I would have told you the same thing. But on the other hand, two things. Mediation is just that. It's mediation is trying to get people to reach an agreement. If they don't reach an agreement, the mediator does not tell me or anybody at the court, I think you or the other side is being unreasonable. All we learn is either it was successful and this is the agreement, or it wasn't successful, and that's it. But if you are declining to go to mediation, you should notify the court. Judge Hessling might feel otherwise, and I'm not holding that against you. That had nothing to do with my judgment. But on the other hand, you might want to tell them, at least in Otsego County, the better policy would be to notify the court. Hey, our attorney has told us don't go to mediation. So
yes, sir.
Just for the future. Okay, we'll send out copies of that. Thank you both very much.
Thank you, Your Honor.
All right, and next is Rachel Daly versus Terry Moore.
Hello, I'm here.
And you are
Rachel Daly.
Rachel Daly. All right. Ashley, is there anybody else here?
There's a Walter Moore here.
Yeah, that's Terry Moore. Mr. Moore, can you hear me? Can you send him a message?
I'll ask him to unmute.
Hello?
Hello, is this Mr. Moore?
Yes, it is.
Okay, I've just called the case. Ms. Daly is here. Give me just a second. All right, Mr. Moore, I know you have some rentals that you rent. This case is not involving a rental. Is that?
You're correct, Judge.
I just wanted to make sure that in that regard, and Ms. Daly, you'd agree that this is not involving a rental. This is just involving your own property where Mr. Moore did some work.
Correct.
Okay, all right. I'd ask both of you to raise your right hands, please. And do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
All right, Ms. Daly, go ahead. What's the basis of your claim?
Improper installation of insulation that we had hired out.
All right, could you go into a bit more detail, please?
Yep. So we contacted Terry to do to insulate our A-frame home in Gaylord. We contacted him in September. We paid him half. The full job was $10,300. We paid him half up front. At the end of October, the materials came in and they started work. The work was completed November 11th, and we paid him the rest of the other half. On December 6th, we were up at our home doing drywall work, and we found that the insulation was completely saturated. Upon doing further investigation, we found that because of what Terry recommended to do, it's called a hybrid system, which consists of 2 inches of spray foam with fiberglass on top. The fiberglass had a paper backing on top of the fiberglass, which creates a double moisture barrier, since the spray foam is also a moisture barrier, which created a lot of moisture in our home, and the water was running down from the peak all the way to the sill plate. And I do have a lot of videos, excuse me, videos and photos that I can share of that as well.
All right. What did you do then?
When we found out this issue, we contacted Terry. He didn't answer at first. We started calling some contractors in the area that we personally know, and we were told that because of that paper backing, all the insulation had to be ripped out because it's going to create mold, it's not going to dry out, and it's going to create further issues. We did finally get a hold of Terry, and he was making excuses, stating that it was humidity in our home when this was December. We did put a humidity moisture detector in there to make sure that it wasn't humidity, and it came back as low. I have a picture of that as well. It was at 39%. Terry did some investigating on his own. He contacted the building inspector. He said that he was looking at AI and doing some Google research, and he did admit that the paper backing and the spray foam do create a double moisture barrier, and he wanted to come in and what he said was do an experiment in our home, cut slits in the paper backing so that the moisture in the fiberglass can dry out, which we declined because if it doesn't dry out, we're going to have a moldy mess. And we said, no, it all has to be ripped out. So we wanted to be compensated for all of the work that was done that had to be ripped out, and he refused.
All right, have you done any repair or remediation work?
We did. We had to have the home re-insulated, and we did the remediation ourselves. We ripped out all of the saturated fiberglass, and because we couldn't hire it out because we were out the $10,000. So we didn't have the funds to have it done professionally. So we ripped it all out and disposed of it, and then had it re-insulated with a different company.
All right, and the claim you've made is for $7,000, which is of course the maximum that you can file a complaint for in small claims court. And did what you had to pay to have it redone, was that more or less than $7,000?
It was, I have it here, and I do have the invoice if you'd like me to share that. It's $6,825 just for that new installation.
All right. And that put it back in the same situation that you thought it was going to be in before or after Mr. Moore completed the work?
Yes, everything's great now.
Okay, all right. When did this take place? Was it last year?
Yes, it was November 11th of 2025 when the work was completed and we paid him. And then December 6th of 2025 is when we found the issue.
All right, okay, very good. Mr. Moore, what would you want to say?
First of all, Judge, I went out there after they complained of it and went down in the crawl space of the home. And if you could visualize a A-frame, a large capital A, if you will, and then it had a subfloor in there and it was on a crawl space. And if you go over to the edge of the home, the last about 3.5 feet or so, you could stand there on the floor and look down and see down in the crawl space. And this is the whole length of the home, 3.5 feet on each side. And that's the crawl space, according to the building inspector, is supposed to have a vapor barrier so you don't get the vapor out of the ground. And that there is no vapor barrier there. I don't know about today, but at that time there was no vapor barrier. They had put rock down there, and if you will, the rock was like a drain field rock for a septic system, and about 3/4 to 1.5 or 1.25 inch size rocks, and there was about 3 to 5 inches of it down all over the entire crawl space. So when I went out there and was looking to try to find out a reason, I mean, the insulation I put in there, I used no moisture, no water or anything. And the insulation I put in there was straight from Lowe's. It was all dry. There was no water involved. I don't know where the water came from. So in my research, I found that there's no vapor barrier underneath that rock. And I imagine the transparency here, when they built the place themselves and they started, you dig a footing and then you pour the footing and then you run the walls up 4-foot high ICF walls, insulated concrete form. You pour those full of concrete, and then they put the subfloor on. I think, I don't know, I wasn't there. And then they build the A's, these big A-frame things, and then they sheet that. But through this entire process, they did all this themselves, and they did it on weekends, from what I was told. And I'm sure that numerous times got rained on, and that put moisture inside that crawl space down there. And then I came in to insulate. Well, there was never any heat in there until I insulated, and then they turned the furnace on. While I was there insulating, the propane company came and dropped a tank, and then they fired up the furnace. And I think that the heat itself started drying the ground out there, and the moisture would rise because heat rises, so the moisture rose also, and that's where the moisture came from, between the two layers of insulation, between the foam and the fiberglass. Like I said, I have nothing to do with any moisture. I don't spray water on anything, or I can't explain where the water came from other than out of the ground.
All right. Ms. Daly, any response that you have?
Yes, for one, we did talk to the building inspector about the vapor barrier. And he said that is not necessary to do until the end of construction. And also, if it was because there was no vapor barrier, there would also be high humidity in the home, which there wasn't. It was 39%. It was in December. And it was because the spray foam and the paper backing on the fiberglass created that double moisture barrier. And I can show you all of those videos and everything else I have if I'm able to like screen share.
What do the videos show?
Us pulling back the insulation and water just running right down. And as soon as we
How
did pull
long-
out all of that insulation, it dried out completely. And the humidity actually went below 39% after all that the fiberglass was pulled out.
Where do you think the water came from?
The spray foam and the paper backing on the fiberglass created the double moisture barrier. So that fiberglass couldn't breathe.
All right. How long after he did the work did you discover this issue?
It was December 6th. So November 11th, we paid him in full, and then December 6th is when we discovered it.
And November 11th was about when he got done with the work?
Correct.
Okay, is there water in the crawl space that he was describing?
No, it's completely dry. And if there was humidity down there, we would see droplets on the ductwork. You know, you would smell it, you would be able to feel it. We do have pea stone down there, but nothing is wet. It's very, very dry.
All right. Did you build this yourself?
What we could do, yes. Most of it has been
Right.
done ourselves.
All right, did you get a building, and I'm not quite sure I know exactly how this happens, but did you get a building inspector with a certificate of occupancy?
It is not done yet, but we have gotten all the building permits, and then once it's completed, we will get the occupancy certificate.
All right, is there a moisture problem now?
No.
All right, the insulation that you put back in or that you had somebody else put in, what's the difference between that insulation and the insulation Mr. Moore put in?
We did spray foam this time. So we could have either done the unfazed fiberglass without that paper backing, or we could have done spray foam, and we just decided to go all spray foam this time to not have any other issues with fiberglass.
All right, Mr. Moore, is there anything else you want to say?
Other than I was asked to do what they asked, to put the fiberglass over top of the foam. They had spoke with the foam insulator prior to contacting, or the foam insulator contracted me and gave me their number and said that they wanted to do this, what they call a hybrid system. They wanted to put foam in and then fiberglass over top of it. So I just done what I was asked to do out there.
So was that, and maybe I'm not understanding, was that fiberglass and foam that you put in?
I just put the fiberglass in. The foam contractor put the foam in.
Was the foam there before or after you put the fiberglass in?
Before.
All right, Ms. Daly, was there also foam there?
Your Honor, his name is Nick Tibbetts. He is the spray foamer. He is the one that directed us to Terry Moore, and said he basically pushes work to Terry. So our quote and what was paid to Terry was that full $10,300 for both the spray foam and the fiberglass. We paid Terry that directly, and Terry paid the spray foamer. I don't know how much. They wouldn't give me, the difference between the two, but Terry got the full $10,300 for both the spray foam and the fiberglass. So he was our contractor, and Terry is the one that subcontracted the spray foamer. And we also did not ask for the hybrid system. If we could, we've done almost everything ourselves. If we knew what to do and even knew what a hybrid system was, we would have done it ourselves to save money. And I also do have text messages of Terry stating that he was waiting for Lowe's to send him the fiberglass before he started work. And he wanted it with the paper backing so that he could staple it easy. We didn't know the difference. We didn't know that the paper backing would have caused an issue because we're not insulators. And everyone we talked to said that is what you learn in insulation school is the two vapor barriers create basically a soggy sandwich is what we were told.
All right, Mr. Moore, was that gentleman with the foam, was he your subcontractor?
Yes,
Okay, all right. And you said that foam was put in first
that's
or
correct.
second?
No, it was put in
All
first,
right,
and when he got finished, probably a week or so later, I went out there with the fiberglass and put the fiberglass in.
all right. Okay. The problem with these types of cases, and it's neither of your faults in that regard, is, if we had been talking, a $400,000 building, you would have each had, an attorney, there would have been an unaffiliated expert who would tell me these things, and say, this is what should have been done or what shouldn't have been done. That's not the case, and that's the purpose of small claims court, because it's not worth paying attorneys $2,000, $3,000, $4,000 over a $7,000 claim. When I first started practicing law, I think the maximum amount was like $2,000, maybe even $1,500. It's just gone up for obvious reasons in that regard. I'm going to think about this. I'm going to make a decision on this. I'm going to, just before we finish here, I'm going to give you each one more chance to tell me whatever you want me, or whatever you want me to consider in doing this. I will have a decision to you within a week. Ms. Daly, I'll start with you. Is there anything else you want me to know?
When we talked to the building inspector, he also sent us in the code book. I also have that I can send you for evidence, basically stating the paper backing is wrong. You cannot have that. And then can I also send over the videos and all of the statements and everything I have?
Neither one of those, and I understand what you said, neither one of those, first of all, I'm not sure it makes a difference, and the rules of evidence really don't necessarily apply, but then it starts getting a little bit complicated. That's why going back to a $400,000 case as opposed to a $7,000 case. And it's probably not going to make a difference on what I can do, because I would need somebody, the building inspector and or an expert in insulation, to explain that to me. I'd have to reschedule this for a hearing and really move it up to the general civil division, and we're here on this. But okay, Mr. Moore, anything else you wanted to say?
None other than the fact that I've been in business for 41 years, and I've never had anything like this approach me before. And the fact that the crying about moisture, I didn't have anything to do with the moisture. Where did the moisture come from? That's the big question. I didn't. The roof is a metal roof. I know wasn't leaking. The roof wasn't leaking. There was foam over top of the metal roof. I just had nothing to do with the moisture that they're complaining about. It had to have come out of the ground, period. That's the only place it could come out of.
Her position is that it basically, and correct me if I'm putting words incorrectly in your mouth, Ms. Daly, but it came because the insulation was not able to breathe. Is that right? And
Correct.
Once again, it's one of those situations. If we were talking a lot more money, there would have been other experts, or at least one other expert out there looking at it and saying, yeah, this is what it should have or shouldn't have happened. But that's not where we are. So I have to give this my best shot, which I will.
Judge, she mentioned that there was a 39% moisture content in the house. That's awfully high.
Okay, well, all right. Okay, all right. I'll make a decision and get it out within a week. Thank you both
Your
very
Honor,
much.
can I ask a question to Terry?
Well, go ahead and ask the question. I'll let you know if it's appropriate for here or not.
Terry, have you ever done the hybrid system with the 2 inches of spray foam with the paper backing?
So we're not going to get into that, and I understand that that's kind of cross-examination, which we don't do in small claims court.
Okay.
And I'm not blaming you or anything like that. It's a legitimate question to ask, but this is it can open a whole other can of worms. Once again, if we're talking a case that had a couple more zeros after it, you guys would be doing that, or your attorneys would be doing that. But this, and I realize 7,000 is a lot of money, and in our day and age, it's also not a lot of money. So, but like I say, I'll make my decision, and I'll send that out. Thank you very much.
Thank you.
Well, let me ask one more thing. Did this case actually end up in mediation or not? And I don't need to know
I
why.
heard-
Did it go?
No.
Okay, and you guys, and you don't know what I'm going to decide. The advantage you have in mediation is you guys get to have the input and stuff in the sense of coming up with an agreement. If you go to mediation and you don't reach an agreement, all I learn is you didn't reach an agreement. I don't learn what anybody offered to resolve it or anything like that. And if there is an agreement, I'm told this is the agreement and that's what I do. So I'm going to ask you separately, and I'm not going to hold it against you one way or the other. If you wanted mediation, I would send it to mediation. It happens pretty quickly. If it was unsuccessful, I will make my decision anyway. If it is successful, I'll do what is there. Ms. Daly, do you want to try mediation?
I'm willing, yes.
Okay. Mr. Moore, are you willing?
Yes, sir.
Okay. It will be sent there. Ashley, are you still here?
I am.
Could you send this to mediation?
Yep, I will go ahead and send that over to them.
Okay, and what happens when it goes is, and Ashley, correct me if I'm wrong, the mediation group gets your phone numbers and they will call you. They will leave a message. I'm assuming you both have answering machine capacities on your phone. When you get that, if you're not there to talk to them, call them right back because they move pretty quickly. And, you know, this is nothing you appear to in person. I'm not sure if they do it by telephone or by Zoom, but they will do it. All they will tell us is there's an agreement, and here it is, or there isn't an agreement. I mean, in some ways, it's apparent you guys got along. I mean, you're not here, like I see in some cases where people want to wring each other's neck, even though you're both unhappy with the procedure. So I would urge you guys to compromise to the extent that you can, you know, recognizing that I'm going to be not taking a shot in the dark, but I'm not going to have as much information as really either of you have. But I will do my duty and make a decision if I need to. On the other hand, if you guys reach an agreement, wonderful. So, Ashley, do you have the contact information you need for each of them?
I do.
Okay, all right, we're all set then.
Deborah Brown, she's a CSA, she's on your left, she's in person here.
Who's she got? Who's her attorney? Ms. Brown, come on up. What's it?
I have difficulties to allow information.
All right. All right. Good morning, Ms. Brown. Why are you here? Let me figure it out. All right. All right. Let me look at this paperwork.
Judge, I do believe this is something that was on Mr. Lecky's docket. May I come into the courtroom to handle
Yeah,
this?
please. Yeah.
I'll be there.
I just noticed you guys got notice. Yeah, come on in.
I'm going to leave Zoom. I'll be in there momentarily. Thank
Yeah,
you.
yeah, come on in. Your appearances or appearance, Mr. King.
78774.
Go ahead.
Here should be another honor. My understanding that office contacted the complainant and the complainant is not objecting to the expungement.
Wonderful.
People should disqualifying businesses or brave for people to have that option.
Thank you. All right.
You have to bring it.
Did you bring an order?
Just to completely fill out an order for this. I was not supposed to bring anything.
Okay.
You gotta read the instructions, that's.
Yeah. I'm gonna grant your order, but you gotta have an order for me to sign to make this happen. Okay, well, it's not our job to tell you how to get your expungement, ma'am.
Take them to the court downstairs.
Okay, goodbye. Then we're done. We're done then. See you. And you're leaving. Bye. And you want to argue with me, so leave my courtroom. I'm just telling you, it's not our job to tell you how to do this. You've chosen to do this process. We don't tell you how to do that. And I'm telling you, you need an order. So go get an order, fill out the order, present the order. You don't have an attorney. Okay? Attorneys know about orders. You've chosen to do this on your own. You got to read those instructions better because you got to have an order. I'm telling you, I'm going to give you what you want, but I'm not going to do your paperwork for you. Understood? Bye.
Okay,
Get out of my courtroom. I'm done with you. Get out of my courtroom. Take her out of here or take her to the jail. I don't care. Get online. Do your research. One more word, contempt of court, 1 day in jail. That's 1 day. That's 1 day. Because you can't keep your mouth shut in my courtroom. Put her in. Put her in. What do you got?
Oh, I'm not sorry.
2 days if you say another word. Shut your mouth and go and sit down. Go ahead.
He's
Okay.
said that he was in bankruptcy court in Mango.
1 hour later.
Ms. Brown, come on up to the podium. Take a couple deep breaths. I mean, like, do it. Deep breaths. What happened? You got so worked up. Where did you get your expungement paperwork? Some website?
Went to the college, to Wednesday.
Okay. Okay. And they helped you fill out the paperwork?
Yeah.
Okay. Let me try to explain something to you. Courts speak through their orders. Okay? What you're trying to do with an expungement needs a written order, a piece of paper that says on such and such a day, today, somebody, me, ordered an expungement. And then there's all kinds of details that go into that paperwork. It's a form that just has to be filled out properly and submitted to me. But I don't do the paperwork. Okay? Now, if you had somebody at the college that was assisting you, then they missed part of the problem or process, because when you're asking a court to do something, you need to have an order. So if the court says yes, the court can sign the order. You follow me? Yes? Okay. I think, I've never done it, but I think you can probably find an order online, fill it out, and bring it back to the court. If nothing else, go back to whoever helped you get to this point and tell them, the judge said, I got to have an order. Help me fill out the order. Not yet. I'm willing to sign the order. I'm just not willing to type it up. Okay? Go ahead.
So I did get paper from the college. I did submit paper downstairs to the list.
Yeah.
Months ago, I submitted it to.
Where's the file?
To you guys. And I submitted it to the state police.
Right. I got it.
So I'm stating you guys.
None of that's an order.
Oh.
What you submitted was the application to set aside the conviction. Okay? And you did everything right. It went to the prosecutor, went to the AG's office, it went to the court, but this isn't the order. Technically, they shouldn't have taken this because you didn't sign the proof of service, but okay, but there's no order. So I can grant this, but it doesn't count unless there's an order. You follow me? So just wherever you want to play around online, you could probably find instructions online. Once you get that, where you live, I didn't even look, where you live. All right, so what'd you give her?
The order number.
Okay,
I can
so-
put my email on the back. Or you just have to put it back through the contact us email.
all right, so you don't have to come back. Get the order, email it to us through our website. Okay? That's all you gotta do.
Just make sure it's completely filled out.
Okay, we're gonna get you there. You good? Go away. Thank you, Ms. Jones.
All right, Casey, I'm gonna do an arraignment, and in the process of that arraignment, I'll also advise your client of his rights by entering a plea. Good morning, sir. Are you James Hammond?
Yes, sir.
You came in this morning for a pretrial. You had a charge of driving suspended, which they're gonna dismiss, and no cycle endorsement. And you're gonna having no operator's license on your person and disobeying a stop sign. No ops on person is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. It carries no points. That's one of the benefits of that charge. Driving suspended carries 2 points, and it requires that your license be suspended. Prosecutors agreed to dismiss that, and then you would admit to the civil infraction of disobeying a stop sign, which is $120 fine. You understand?
Yes, sir.
That is a misdemeanor, even though it's a very minor one. And for you and for Mr. Smith, do you understand that if you do plead to a misdemeanor charge, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yeah.
If you had a trial, you'd have the right to be represented by an attorney. All you gotta do is ask, and we could appoint an attorney to represent you. Mr. Smith, you have an attorney. Ms. Strong is there with you. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state is able to prove your guilt beyond a reasonable doubt. You understand all that?
Yeah.
All right, give me a second here and make a note. Angelique, are you gonna do the competency hearing?
I am.
Very good. We'll get right to that. I'd like to have you back.
And just for the record, Your Honor, I think the court previously said Mr. Smith and Ms. Strong, but this is Mr. Hammond and he represents himself. I just
Yes,
wanted
but
to
I
have
I
that.
was going through the rights so Mr. Smith could also hear them.
Oh, understood. Thank you.
So, but they're watching on the live stream.
Great. Okay.
Other than this plea agreement, which I placed on the record, did anybody promise you anything to get you to plead to this?
No.
What's that now?
No.
Were you driving a car that day and you did not have a valid driver's license in your pocket or in your vehicle?
I was on my motorcycle and I was on my way home from work.
But you didn't have a valid license at that time?
Correct.
Where do you work?
At LRS in Niles.
That's a hefty drive. I had to go over to Niles for court. It took me a while to get there.
It's about 45 minutes each way.
I think you told me that before. No ops in possession. 257,311, as I said, carries no points. Does carry a $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. Did you fail to stop at stop sign?
I did.
Smith, DWS, and no cycle endorsement. Do you have a cycle endorsement? No?
No, not yet because my license is suspended.
All right, on that ticket, it's $120. And that's due by July 16th. So the total you owe is $320. Can you pay that today or do you need time to pay it?
I can pay it today.
Very good. All right, you got somebody that brought you here, and that's good. Don't drive anymore till you get this all squared away. This was a pretty good plea offer, doesn't carry any points, and the other charges were dismissed. You go out to the counter, and they'll have you pay the fine, and you're good to go.
All right, thank you.
Well, I'm going to stop the record and restart it. This is file number 26642FY, People versus Charles Robert Smith. Is that you, sir? Mr. Smith is presently at the jail with a Zoom connection to the court. He's there with his lawyer, Casey Strong. She's not quite in the frame, but we can see that she's there. She went out to the jail to meet with him. Mr. Smith is charged with resisting and obstructing a police officer as a second or subsequent offender, which is a felony punishable by up to 3 years imprisonment. Mr. Smith was arrested in April on this charge, April 8th. I believe he's been in custody since that time. He was sent for an evaluation at the Forensic Center regarding his competency. The Forensic Center sent us an update in May and said that they were working on the report and would expect to have a report soon. We got a report. It's dated June 4th. It was received on June 11th. And when you get the report, the court is supposed to set this competency hearing within 5 days, which we have done, unless there's good cause to show why you can't do it. Your lawyer, Ms. Strong, was scheduled to be here today. I came back from vacation today. So we set the hearing for this morning. Also present is Assistant Prosecuting Attorney Angelique Camfield. Mr. Smith, I got the report from the Forensic Center. As I indicated, it's dated June 4th. And the report was prepared by Aaron Saracini, Ceresnie, Ceresnie, PsyD, licensed psychologist and consulting forensic examiner with the Center for Forensic Psychology. Ms. Strong, on behalf of the defendant, would you stipulate to the admission of the report?
Yes, Your Honor, in review, please, pieces of the report we find it, we would stipulate to the entirety of the report.
Ms. Camfield, you agree?
Yes, Your Honor, I will so stipulate.
Mr. Smith, we've met before, and I know you've been struggling a little bit. I got the report from the doctor, and it says that you were cooperative, responsive to their questions. He put forth sufficient effort during the interview with intact short-term and long-term memory. His capacity is estimated to result within normal borderline range on his known history, vocabulary, and verbal reasoning. They indicate that you did understand the nature of the charges and the process which goes with it. The doctor gave this opinion. Mr. Smith was cooperatively engaged in the evaluation. I did not observe any behavior indicative of an intellectual disability or other cognitive, psychological, or psychiatric issues that impeded his adjudicative capabilities. In my opinion, Mr. Smith is aware of the accusations against him and how they arose and considered his defense options with reasonable expectations. Mr. Smith understands how the court works, the roles of the primary legal personnel, his defense options, and possible outcomes, and clearly voiced his preferences. It is my opinion that Mr. Smith is able to understand the nature and object of the proceedings against him and rationally assist in his defense. It is therefore my opinion that he is competent to stand trial. Ms. Strong, you've read that report and you accept that finding?
Yes, I do.
Ms. Canfield, do you agree?
Yes, I would respectfully request that the court base its finding of competency on Dr. Serensi's opinion.
All right, I have an order finding the defendant is competent to stand trial. The case shall continue on to the next stage of the criminal process.
Your Honor, if I may, I believe there was an offer of disturbing the peace. Should there be an adjudication of competency?
Yes,
That still remains.
all right, we're gonna get to that. Mr. Gabriel and Ms. Strong had discussed this, and Ms. Canfield is here to confirm it. The prosecutor would dismiss the felony charge and the supplemental portion of the information alleging a previous felony if you enter a plea of guilty to disturbing the peace. Disturbing the peace is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. You have been in jail for 70 days. Ms. Strong, did you discuss that plea offer with your client?
I did, Your Honor, and it's my understanding that he wants to take that offer.
All right, Mr. Smith, are you going to plead guilty to disturbing the peace?
Yeah.
And you heard me go through the advice of rights just a moment ago. Do you understand you have those same rights and you'll be giving those up by entering this plea?
Yeah.
Anybody threaten you to get you to plead to this?
No.
Promise you anything?
No.
Well, let's talk about this. According to the report, you were at the Dollar General and they believe that you had taken some items without paying for them because you were hungry. And then you were sitting outside the store eating the stuff. Is that accurate?
Yeah.
All right, then the police tried to discuss that with you and they were going to take you in custody and you didn't really want to go, so you didn't struggle a little bit while they tried to put the handcuffs on you?
No, they attacked me.
All right. Well, tell me your version.
They attacked is what happened.
All right, well, you were sitting there and you'd taken this food without paying for it. I guess that's sufficient right there. Then did they take you into custody?
No, they attacked me.
All right, well, they took you to jail, didn't they?
Yeah, after they attacked me.
All right. Now, let me ask you a couple questions. Where are you going to go today if I let you out of jail?
I don't know. I don't have nowhere to go.
Talk to Lauren, the the jail liaison?
I'm gonna speak with her before I leave today, Your Honor.
Canfield, are you satisfied with the disorderly based on the larceny facts?
Yes, Your Honor, and I believe that what the defendant described would create a disturbance in the public area outside the store.
Mr. Smith, I don't want to just dump you out on the front steps of the courthouse. So I'm gonna order. There's good time calculated, there's 5 days a month. 70 days. I'm gonna order 83 days, credit 70, leaving 13 days to serve. That should be enough to get some help from the mental health specialist at the jail. Ms. Strong, you're gonna contact her directly?
I'll speak with her before I leave. Try to get you some.
And I'll do $125 minimum fine and costs or 2 additional days in jail. We're gonna take a day or two, Mr. Smith, to try to find a place for you to go. I don't want you to just be standing on the steps of the courthouse with no place to go. Do you have people anywhere? You were from Sturgis originally, is that correct? Well, where did you grow up? What town? Where?
Yeah.
Well, I don't want you to get out and get immediately rearrested. So we're gonna try to set up some sort of a plan. I didn't realize this was gonna be a misdemeanor plea till just before we came in. I don't have any quarrel with it, but I would have maybe tried to make some prearrangements. At any rate, you're gonna be there a few days, get 3 more square meals a day until we find a place for you to go. And I will note that Casey Strong is gonna work with our mental health liaison, Lauren Frank, who does a very, very good job. All right, Mr. Smith, you're good to go. Thank you.
Thank you. Thank you.
Evelyn Valerie Cook,
Thank you, Your Honor. Have a good day.
222-705-215.
Good morning, Judge and staff. John Graziani, appearing on behalf of Evelyn Cook, Judge.
Ms. Cook, your name, ma'am? Why is she still in custody? It looks like she posted her bond.
She did post the bond. That's what I was about to ask you, Judge. And I was asking, I want the release. She is a nurse's aide and she's taking care of a gentleman at the.
All right, let's get them back here somehow. Yeah, it looks like the bond was posted this morning.
Yes, sir.
We'll get the person back, hopefully. Okay, here we go, Mr. Graziani. Thank you. People against Evelyn Valerie, 22T-705-215. Ms. Cook, your name, ma'am?
Cook.
Okay.
Evelyn
Yep.
Cook.
All right. Thanks, Deputy. And Mr. Graziani, your name?
John Graziani, P number 43387, on behalf of Evelyn Cook.
Ms. Cook, your name again, ma'am.
Evelyn Cook.
Tell me what's going on here. You pre-tried this with the prosecutor, right?
Yes.
No,
Judge, I have not retried this matter with the prosecutor.
Oh, this is a Trenton case.
It is a Trenton case, Judge.
It's not a state case.
It's a state case.
Oh, it is a state case. All right. What is the issue here?
Judge, what happened is this goes back the good old days of COVID. It was Miss Cook's understanding that this matter was dismissed. I recall in conversations, I told her that there was a possibility that this could be dismissed without giving out any strategy. It appears that the son of the alleged victim pled to a larceny, which would absolve Ms. Cook of any liability. And here's where we're at right now, Judge.
How in the world is she gonna have you come in here and tell me she thought this case was resolved?
Judge, I get it, but this is what she thought. She is a caregiver. She is a nurse's aide through the state of Michigan for the past 24 years. She's been locked up for about a week right now in the jail. The bond has been posted. As you could tell, it was a 10% bond. The bond was posted. I'm just asking right now for her to be released. And if you have concerns about her not showing up, even though I don't like the tether thing, put her on the tether, sir.
Ma'am,
Yeah, yes, Judge.
Please let the judge speak.
please don't tell your lawyer you thought that the case was resolved. It insults my intelligence. It really, truly insults my intelligence.
Yes, Your Honor.
Now, I don't want to hear this nonsense anymore. Don't tell your lawyer you thought the case was resolved when you knew the case wasn't resolved. We've been going round and round on this. You were in here. I arraigned you in September of 25, and you posted a 4,010% bond. So please save the lies for some other judge in some other court on some other case, because I don't want to hear them anymore. Do we understand each other fully and completely?
Yes, we do, Judge.
Then don't tell your lawyer lies, knowing that he's going to repeat them to me. Do we understand one another?
Yes, we do.
Good. I shouldn't have to tell you this unless you're 8. Now, that being said, why is she still in there if she posted the bond, Deputy? Can you tell me your name, sir, and tell me why she's still in custody?
How you doing, Your Honor? This is Barbara Senior. From what I understand, she's probably in here because she maybe have another warrant or something that popped up. So they had to go through court today, and now she should be able to be released. Whatever case she had going on today, they usually hold it until she goes through court and finishes that, and then she should be released today. Unless there's any holes somewhere.
I understand. So what do you want me to do? Adjourn this again?
Judge, I need this matter adjourned because I'm not in a position to really talk with her at this time. I feel
okay. Fair enough. Do you live in Wyandotte still, ma'am, on St.
Yes.
John's?
Yes.
Now,
Yes.
I'm going to tell you something. I'm adjourning this for 1 week, and you are going to appear in person.
Correct.
Do we understand one another?
Yes, we understand one another.
I have a good mind to raise your bond to a amount that you would never be able to post, because you have missed court date after court date after court date on this. And I'm not going to play games with you. Do we understand one another?
Correct, we do understand one another.
And we understand that we're not going to lie through our lawyer by Zoom, in person, or otherwise. We understand that, right?
We correctly understand that, yes.
Because if I didn't think you understood that, I would set a bond that you're going to have to hire a heart surgeon to post the bond for you. And you are going to be sitting in custody until the cows come home. Do we understand one another?
We understand one another,
If you
Judge.
do not show up next week, I will write this down, 100,000 cash or surety, and I will call up the Wyandotte Chief of Police and ask them to have you arrested. Do we understand one another?
We do, Judge. Yes.
I don't get the whole lack of respect thing going on there. My God. I just don't understand it anymore. June 23rd, you will be in person, and you will be here at 9 o'clock in the morning. Do we understand one another?
We do understand one another, yes, Judge.
Now stop playing games with me. Do we understand one another?
Yes, we do, Judge.
Good.
Judge, for the record, Ms. Cook, once you get out, you can call me. The number is area code 734-246-0000. We can resolve this matter, but you have to call me, ma'am, please.
Thank you, Deputy, for your time.
No
Good
problem,
luck
Your Honor.
to you, Ms. Cook. I will treat you fairly. unless you don't show up next week, in
I'll
which
be
case I
there.
will write down 100,000 cash assured. You
I will be
understand?
there. Yes,
Good luck.
sir.
Thanks, Judge.
Thank you.
Thank you, Your Honor.
Thank you, Deputy. You got a flat tire.
I have pictures.
I believe you. I'll call the case. We go from people against Michael Andrew Felsky, 26W703-474FY.
And we had a voucher P80177 on behalf of my client who should be logging on to Zoom and he's logged on.
Michael Andrew Felsky, 26W703-474. Mr. Felsky, your name?
Michael Felsky.
Good morning again, Your Honor. We had a voucher P80177 on behalf of Mr. Felsky.
All right. Where are you, Mr. Felsky?
I'm at home because last night when I was coming up for court after work, my tire on my work vehicle blew and I had to have it towed.
So we can adjourn it a week.
Your Honor, the problem with the week is I started a 3-week-long trial in the criminal justice complex in front of Judge Van Houten. And then the week of July 13th, I have a pre-planned vacation. So I'm not available until the end of July.
Oh my God. Why can't you get it fixed and drive up here now?
I don't have the money to fix the tire right now. And it's a work vehicle, so I gotta wait for work to handle it.
Just gonna go.
I do anticipate it going, Your Honor. I was going to ask for an adjournment because my understanding and speaking on this as Morrow, the people intend to increase the charges when I hold from an RNO to an RNO causing injury for an officer Lyles from Brownstown. I've been requesting additional discovery materials and I can place all of that on the record. The majority of them were sent to me last night at almost 9 o'clock. Body camera that I haven't had time to review. I'm missing medical records, which I believe we're going to ask for a protective order from Your Honor to sign so I can get those, as well as a number of reports. I can go through the whole list of things that were not included that I've been working with the prosecutor's office to try to get prior to holding the exam. I would need time to review those materials. I certainly think they're relevant, especially if the people are going to try to increase the charge to an RNO causing injury, which has an element that medical attention is needed.
I got it. So you intend to do that? Are you insisting that the exam be held?
They are not insisting, Your Honor. My client wishes to hold the exam. And my understanding is if he's holding, the people are going to seek to increase to that charge.
And that's correct, Your Honor, regarding discovery. Almost everything has been sent. I am in possession of medical records and I am currently typing up a protective order for this court to sign so that I can get these over to Attorney Belcher.
Boy, this is not good. So you're saying you can't do it until the 3rd week of July?
Your Honor, I wish that I could do it sooner. However, I'm starting a 9 complaining
No,
witness.
but is that what you're saying?
Correct. The first Tuesday that I'm available, Your Honor, is July 21st. I can clear my schedule and make sure that I'm here.
I don't know why you needed to take a work vehicle. I have a good mind to issue a warrant for your arrest. You know that?
I don't
say you had to drive a work vehicle. I don't care how you get here. You needed to have somebody drive you here. This is a preliminary exam. I can't. This is going 2 months now. Where are you in Sandusky?
Yes, sir.
Remind me how far that is.
It's an hour and 45 minutes to
Good. Get your tail here. We're going to do it this afternoon. Any reason you can't do it this afternoon?
Your Honor, I'm subpoenaed to testify in a preliminary examination down the hall at 1:30, where I'm a complaining witness or a witness.
That's correct, Your Honor.
I would be in the building.
Well, that's fine. That's fine. You figure out a way to get here, young man. We're going to do this. I'm going to set it for 1:30. I will take it after. Oh, you don't have the discovery.
That's, Judge, I have to.
Why did you guys wait to give them the discovery so late? Why did it take so long? I mean, this case been going on since May 22nd.
Your Honor, if I may, I don't believe Ms. Asmara was aware of what was missing. So what happened was we appeared for the probable cause conference. At that time, I only had paper. Ms. Asmara sent me everything in evidence.com. When I started reviewing everything in evidence.com, there were 14 different video files. There are 3 different policing agencies involved in this case.
Woodhaven, Brownstown, and Trenton. I only had 14 videos from Woodhaven. Last week, I did send an email to Ms. Asmaro identifying all of the things that were missing. The 911 call, additional body worn camera from the 2 other agencies, use of force reports, medical records. My understanding is I sent that email towards the middle or end of last week. Ms. Asmaro made contact with the officer in charge yesterday. Some of the items were sent. However, they again only sent items for Woodhaven because the officer in charge is.
Are you confident that that other case is going to take 3 weeks?
I sure hope not. I don't even want to try the case, Your Honor.
Okay, well, I'm just trying to figure out if I can't do it a little earlier.
Judge,
Do we have somebody sitting for me on the 7th, Lisa? Just, I get it. Just give me 1 second. I just want to ask.
No, Judge Heston will be handling all the PCCs.
And your trial starts,
next Monday,
which is the 22nd.
22nd. And we go Monday to Thursday. We do not have Fridays.
So 21st, 28th. All right, here's what I'll do. I'll adjourn the PCC to the 7th, okay? If you're still in trial, you guys submit a stipend order to adjourn and I'll sign it. All right? We'll adjourn the PCC to July the 7th at what time, Lisa? 9:30?
Yes, 9:30.
Make it or note adjourn if defense attorney's still in trial. You'll just have to submit a stipend order, okay? No, I'm not gonna. It sounds like she's still gonna be in trial then, right?
I anticipate.
So that's what I'll do. I'll adjourn the PCC. Sir, you have the right to a probable cause conference within 14 days of the date of the arraignment.
Judge, has previously been waived on.
Has it?
Yes.
All right, so we're gonna set it for July 7th at 9:30, and then July 21, I'll do the exam, Lisa, since you're not available the week before, right?
That is correct. I'm out of the.
PCC will be July 21 at 10 o'clock, Lisa, or you want a different time?
For the exam,
Yeah,
10:30.
10:30.
Yes, Judge.
Okay, sir, I'm gonna tell you, you have to make sure you're here. If you don't, I don't care what the excuse, you should have made arrangements to get here today anyways. If you don't get here, I'm gonna issue a warrant for your arrest. Do we understand one another?
Do I need to be there by 1:30 today?
Not coming today. You're having to come here by Zoom on July 7th at 9:30 unless you hear from your lawyer, and you need to appear in person for the exam on July 21 at 10:30. Do you understand that?
Yes, Your Honor.
So I don't care if you have to get a hotel overnight on the 20th to make sure you're here, but I'm telling you, you have to be here on the 21st. I will not adjourn any of these dates except as I already stated. Okay?
Thank you.
Good enough. Have a good day. Thank you.
Court calls case, People State of Michigan versus Kevin Davis.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. James Fifelski, appearing with and on behalf of Davis, who's approaching. Come up. Just state your name, please, for Judge Simpson.
Good morning, Your Honor. Kevin Ryan Davis.
All right.
Your Honor, this is the date and time set for preliminary examination. I believe we're ready to proceed to an exam.
We are as well, Your Honor.
All right, let's go.
We'll call Officer Anderson.
Clerk, please come forward and be sworn.
Right now. You sound shoot, yeah.
I did.
State, spelling and record.
Niconi Anderson, NAKONAANDERSON.
Thank you. You may be seated. Mr. Cook, you may inquire.
Thank you. Good morning, officer. How are you doing?
Good.
Doing fine. Sir, how are you employed?
Pittsfield Township Police Department nursing.
How long have you been working with Pittsfield Township Police? Any previous law enforcement experience? In what capacity do you work for Pittsfield Township Police? Can you describe what your duties are as a road patrol officer?
Take complaint calls.
Were you working in the same capacity on or about April 6th of 2026? Going to that day, were you working that day? And At any point were you dispatched to 2931 Carpenter Road?
Yes.
Is that here in Washtenaw County? What were you dispatched for?
Male screaming, obscenities, disorder.
Were you with anyone else or was it just yourself?
At the time of arrival, I was by myself.
What did you do when you arrived at that? Or can you describe what's at that location?
It's an abandoned lot. The call came in with a neighbor from a neighboring business, a nail salon. That was the complainant. That the male was located in an abandoned lot next to say.
When you say the male was in the abandoned lot, who is the male? And you sort of gestured a little bit. Can you point to and identify, or do you see that individual in the courtroom today? Can you please point to him and identify him by an article of clothing that he's wearing? The record may reflect this witness has identified the defendant.
That objection record shall so reflect.
Where did you find the defendant?
Leaned up against, or sitting down on the ground against a 3-foot brick wall. Side of the abandoned lot.
How far was that from the business that you said made the call?
35, 40 yards.
All right. What was the defendant doing when you first saw him?
So I rounded the corner. He was actually puffing what appeared to be nitrous oxide.
What did you do when you saw the defendant?
I told him to stop and put it down. And he continued to huff.
Did the defendant say anything at that time?
He told me, pardon my French, to fuck off. And told him to stop, to put it down. Then he told me to suck my dick, or suck his dick.
Did anyone else ever arrive on scene to assist you?
Officer Gonzalez did.
Do you know what Officer Gonzalez's first name is? When did Officer Gonzalez arrive on scene?
Shortly after I made initial contact, as he was argumentative, and so I asked her to step it up, and she arrived very quickly after.
While all of this is happening, what were you wearing at the time?
This exact uniform, the Class C department issued.
And I see there's some patches on the shoulder. Are those your police patches?
Yes.
What were you doing, or what did you do with the defendant at that point?
At what point?
So you said that he made some expletives. What did you do after that?
I asked for my partner, Officer Gonzalez, to step it up due to him being under the influence, what appeared to be nitrous oxide, actively huffing, and his argumentative behavior towards me, dislike for PD or whatever. I asked her to step it up. I attempted to grab the nitrous from his hand at that point. He turned away from me and kind of tensed up due to his physical nature. I wasn't comfortable doing hands on my partner.
At any point, did you put hands on the defendant?
Once Officer Gonzalez showed up, yes.
What happened when you put your hands on the defendant? Why? Let me rephrase that question. Why did you put your hands on the defendant?
I attempted to stand him up to take him into custody for upgrade.
At that point, had the defendant been resisting you physically?
Not physically. Well, I mean, he had tensed up, but
Was he actively fighting back at that point? At any point, did the defendant start to fight back?
yeah, he came to kind of pushed off of us, stood up very aggressively, and then eventually charged Officer Gonzalez.
Said charged Officer Gonzalez.
Other than charging Officer Gonzalez, did he make any other, or did he physically resist in any other way at that point?
Prior to him lunging at Officer Gonzalez.
Okay, so you said he charged, and now you're saying at some point he lunged?
I would describe it pretty much the same.
Okay.
Yeah, he ran towards him.
Did the defendant ever swing at either you or Officer Gonzalez with his fist?
Not at me personally. He did it when he ran at Officer Gonzalez. It appeared to me that he was getting shot or pushed her.
Did you hear if Officer Gonzalez ever exclaimed anything about being attacked?
She advised that,
Objection, hearsay.
It's an excited utterance, Your Honor.
Overruled. Go ahead.
she advised that she was struck in the face by Mr. Davis.
Did Officer Gonzalez ever exclaim anything about the defendant grabbing her?
Objection, hearsay again, unless it can be contextualized. If it's claimed to be an excited utterance.
Well, I don't, they're engaged with a suspect at that time. What do you mean contextual?
Well, if he's just asking a general question about what she said, we don't know the timing in which she's saying it. If it's not an excited utterance.
During the engagement with this defendant, that the statement would come. Just okay. Overruled. Go ahead.
Other than him pushing her while he was still seated on the ground while we were attempting to get him up, she did say out loud, "Stop squeezing my hands," or "Stop."
What did you do after the defendant lunged at Officer Gonzalez?
I took my permanent issued Taser 7 out of my holster. I activated it. Once he made contact with Officer Gonzalez in an aggressive manner, I deployed my taser.
Was that taser successfully deployed? After you deployed the taser, what happened then?
Mr. Davis fell to the ground. Verbal orders to roll over onto his stomach and place his hands behind his back, and he did so.
At that point, or following that, was the defendant cooperative?
He's very argumentative. But yes, he was much cooperative actually.
While all of this was happening, did you have a department issued body worn camera? And did that camera capture what happened during this incident? If you saw that footage, would you be able to see it and recognize it? I can have just 1 second here while I get this set up. My apologies.
And
Plugged in, if I can put up my screen for authentication purposes. There we go. Sir, do you recognize what's on the screen right now?
My body worn camera showing the dash of my car.
All right. And this is part of a video, is that correct? Is this video fair and accurate representation of what occurred during this incident?
Yes.
Are people move to admit with March People's proposed exhibit 1?
the objection of what here?
No objection, Your Honor.
Exhibit 1 is admitted.
Thank you. Permission to publish?
Yes.
So 20 for the record, it's 26 minutes, 34 seconds. I'm not going to play the whole video. I'm going to play just the first few minutes that captures the incident. And I'm beginning from 0.
Okay, come on. Go. Have a wall on right there. Now, guys, right on the other side of it. Pull up here, and he's just screaming like blood curdling screams. Fuck you, and there's nobody about it. Fuck this shit. It's just, that's it. Same everything right now. All right, put it down. Oh.
Pull my license. Hey. What am I doing? You're using vertical. I think I'm going to stop. You're not young. Yeah, it's just something that's fine. Yeah, I'm not going to. There's a guy in the back. Let me help you back.
I'm gonna pause the video at 3 minutes and 8 seconds there. We can take me off, please. Sir, there was a female officer in that body worn camera. Was that Officer Gonzalez? If I can have just 1 moment, please, Your Honor. Wait. Pass the witness, Your Honor.
Cross-examination. Officer Anderson, you testified, first of all, this area where you found Mr. Davis was this vacant lot. And that's on the corner of what, Carpenter and Packard?
Yeah, Crystal Packard coming.
If I show you a couple of photos, just to have some still shots of this, would you be able to identify that location? These are, okay. Which one's tagged? I've marked proposed defense exhibits A and B. May I approach the witness, Your Honor? Where? Thank you. Yes. You recognize what's depicted in those photos, sir? And does that appear to be the front and back area, for lack of a better word, of that brick wall where you found Mr. Davis?
Yeah, the east and west side.
Okay. Your Honor, I'd move for admission just for the location.
No objection.
Exhibits A and B are admitted. Thank you. Officer, at some point in the video, we see you taking a couple of bags or trying to take away the canister from Mr. Davis. Is that correct? You testified that it appeared to you that the canister he had in his hands was nitrous oxide, right? And at some point you confiscated those items and other belongings and you took photos of those. Is that correct? You got a picture. That'll be C. And as far as evidence of what you were arresting Mr. Davis for, possession of drug paraphernalia, is that what you confiscated these bottles for? Okay, may I approach with exhibit C, proposed exhibit C, Your Honor? Right. Thank you. Just for purposes of the record, is that the photo you took of The property that you took from Mr. Davis?
Sorry. Almost, but yes.
Okay. Move for admission of Exhibit C.
No objection.
Admitted. When you arrived to investigate Mr. Davis, it was what, around 11:30 a.m., somewhere in that ballpark? And as we can see on the video, it was broad daylight out, correct? You estimated the distance from the neighboring business where you spoke to the gentleman that we saw in the video, 35 to 40 yards or so. Is that fair to say? Is it also true to say that when you came upon Mr. Davis, he was alone against that brick wall? And there's nobody out in that vacant lot or on the side in the grassy area there? And didn't anything else on his person, Mr. Davis, such as a weapon or something that would make you think he was a danger to you or anybody else in the area? Did you? Okay. Also, do you know in that, so there's that grassy area, which would be the east side of that vacant lot. Do you know how far that brick wall is from the road itself, that side street?
I'd approximate maybe like 50 foot.
Okay. You would agree it's quite a distance, more than just from here to the court clerks. Okay. And just to be clear, I assume you didn't see anybody in the roadway that was also complaining of Mr. Davis. Okay. When you came upon Mr. Davis, and we saw in the video, it doesn't sound like he is yelling or screaming at that time, right? So he just appeared, as he did on the video, sitting up against the brick wall and essentially minding his own business.
Yeah.
Okay. Again, just to be clear, did you see any sort of no trespass signs or no loitering signs in that particular area? When you came upon Mr. Davis and you saw him inhale from that nitrous oxide canister, did you believe that that was illegal to possess nitrous oxide?
Using that part.
Okay. And that possession of nitrous oxide or him using it by inhaling it, that was the sole reason you were, I believe, as you said, attempt to stand him up so you could arrest him for huffing, correct? And ultimately, you gave Mr. Davis a citation for possession of drug paraphernalia, nitrous oxide. Is that correct?
I did not.
You did not. If it has N. Anderson on the bottom of that citation, that not be you? Okay. If you take a look at this, may it refresh your memory? May I approach, Your Honor?
Right.
Reviewing that, does that refresh your memory that that was the citation you issued against Mr. Davis? And is the sole charged misdemeanor possession of drug paraphernalia? All right. Just for purposes of the record, I would move for admission of defense exhibit D, as in David.
No objection.
Exhibit D is admitted.
One of the things we saw on the video is I believe before you make physical contact with Mr. Davis by grabbing his arm, you took, it looked like bags that were next to him. Is that correct? What were you doing at that point?
His property away from him. Unknown what was inside and could have been had anything in it. And then his altered state, it belongs to positive.
Okay. And in this particular case, you did draft a police report, correct? So essentially, that is a detailed recollection of the things that you felt were important about this situation. Prior to making contact with Mr. Davis, did you have any awareness of the effects that inhaling nitrous oxide could have on a person? And what was that awareness?
Sometimes when someone's under the influence or it can be aggressive and unpredictable.
And so you had that knowledge leading up to your interaction with Mr. Davis, correct? You saw him huff from this nitrous oxide bottle. And then it looks like while he's sort of in the middle of, for lack of a better word, being impaired by this, you and Officer Gonzalez are making physical contact and trying to get him to stand up so you can arrest him. Wouldn't you have had the option to simply wait and maintain some distance given before you did anything physical with him, given the fact that he's alone in this area where there's nobody else? Wasn't that a reasonable option?
It's not an option.
Because prior to making physical contact with him, he was just sitting. He was maybe saying things that were
Sitting and committing a criminal offense.
well, I guess that's yet to be determined.
No, because if the inhalation of a chemical agent is a criminal offense in Michigan.
Well, I guess that's the question. Is it a chemical agent? And proposed exhibit number E. That's the last.
You referred to it yourself as nitrous oxide.
Yes, Your Honor.
Do you know the statute?
Well, the criminal charge that was charged against Mr.
Doesn't matter whether it
was
charged. It's the offense itself that the officer is viewing. The inhalation of a chemical agent for the purposes of euphoria, excitement, whatever, is a crime.
Well,
so if that's where we're going,
I guess that's,
please get there quick.
I'll save that for argument then. If
Well,
I just may approach with the final exhibit.
Go ahead.
Thank you, Your Honor. Mr. Anderson, were you aware that the citation and the charge of possession of paraphernalia was ultimately dismissed in this court? Okay, that's okay. If you don't know, I would just move for admission of defense exhibit E. It's an official court order of this court, just for purposes of the record that according to the order, it's dismissed because the ordinance does not prohibit this conduct. And I believe it's admissible for purposes of the legality.
Ordinance doesn't. But still, for Pete's sake, any objection?
I would object to relevance, but I think the court could take judicial notice of it since it's from this court and easily use as the court's information, but.
And that's all I'm at.
I don't know what it's gonna matter, but what the heck, we'll just admit it. You do understand that state law is different than an ordinance, and that a determination under that was made that it did fit the ordinance. That doesn't mean that there wasn't a crime. You do understand that, Mr.
I understand the distinction, but I would also argue that inhaling nitrous oxide is not a violation of state law.
Really? I can't wait to hear that. All right, go ahead.
All right, thank you, Your Honor. Officer Anderson, would you agree with me that prior to making physical contact with Mr. Davis, he was sitting stationary, doing his own thing? In other words, he wasn't getting physically aggressive or combative toward you or Officer Gonzalez until either one or both of you attempted to make physical or did make physical contact with him, correct? All right. And at one point in the video, we see, well, we hear Mr. Davis say, "No, I'm not going with you." Remember hearing that? And that would have been an expression where he's essentially saying, "Leave me alone. I'm going to stay here." Yes? Was there, when you heard the things Mr. Davis said that nobody would like to hear, was there any attempt by you or Officer Gonzalez to engage in further conversation or de-escalate the situation so it didn't get physical? Did either you or Officer Gonzalez, before making physical contact with him, identify yourselves as police officers? Did you or Officer Gonzalez, before making physical contact, simply ask him to leave on his own accord, get out of this area?
Because he was breaking the law, so we were going to take.
When you saw that Mr. Davis was had huffed, and as we said, for lack of a better word, under the influence of this, had you or Officer Gonzalez radioed for HVA paramedics? And was there any? I'm sorry.
Officer Gonzalez.
Okay. And so you knew they were on their way. And would you not have been able to simply maintain a controlled situation to allow them to come in and do a medical check before you made physical contact with Mr. Davis?
Just speculation. Don't know what.
Sustained.
Final few questions, Your Honor.
Let's hope.
When we see Mr. Davis get up from the wall after you and Officer Gonzalez made contact with him, did it not appear to you that he was attempting to walk between the two of you before it appears that Officer Gonzalez pulled out a taser on him?
Yeah.
Okay, was there a space between you and Officer Gonzalez that he could have walked through? Would you have allowed him to walk through? Okay. After Mr. Davis was tased, and we saw in the video, he's on his back, you tell him to roll over, takes him a few seconds, but he does so, correct? Tell him to put his arms behind his back. Once he takes a couple seconds, he does that, correct? And as you testified, he was cooperative after that point and onward.
It's perfectly argumentative, but yes.
Not physically resisting. Okay. And you're, again, actually, I'll withdraw that question. No further questions, Your Honor.
Let me redirect.
To 2 questions. Officer, how many different markings are on your uniform that identify you as police?
5.
And
Bag. That big silver thing on the front. Yeah, got it.
was Officer Gonzalez wearing the same uniform as you're currently wearing? Nothing further, thank you.
Had a big badge. Yeah, okay, just checking. Anything else?
Nothing.
Officer, you may step down. Thank you.
People have no further witnesses. Defense has no witnesses, just argument. People move for bind over on the information. I believe it should be single count of resisting and obstructing. Court heard testimony and saw a video of this incident where the officers were attempting to apprehend and arrest the defendant for violating MCL 752.27. That be the inhalation or consumption of chemical agents, including nitrous oxide. I believe that attempted arrest was lawful, and the court saw the defendant lunge at Officer Gonzalez during the commission of those duties. Certainly, he knew that these were police officers based off of the numerous markings indicating that they were police officers. He knew that the amount of force they used was reasonable, especially when the court again saw the initial attempts at just standing him up gently, getting him on his feet, and then he became aggressive. I would ask the court bind over on the information.
And so that you can frame your argument, I think that it's appropriate that actually there be 2 counts of resisting and obstructing, but go ahead.
Your Honor, under the resisting and obstructing statute, one of the elements that the Supreme Court has recognized is also an element for purposes of bind over is that the police officer gave the defendant lawful command, making a lawful arrest, otherwise performing a lawful act. And in various statutes, it talks about if a misdemeanor offense, which has a punishment of more than 92 days incarceration, then a person can be arrested for that by statute. That's 76415. The case law, and I'll get to the chemical agent, but my argument essentially, Your Honor, is nitrous oxide is not a chemical agent. But the first part of that is,
where does that come from?
752271. And there's 2 areas.
Specifically, does it specifically delineate that nitrous oxide is not a chemical agent?
It does not, but by its description, the definition of chemical agent, 752.271, as used in this act. The act is what prohibits, for the purpose of causing a condition of intoxication, intentionally smelling or inhaling the fumes of any chemical agent. And it's defined as any substance containing a toxic chemical or organic solvent or both, having the property of releasing toxic vapors. Term includes, but is not limited to, glue, acetone, toluene, carbon tetrachloride, hydrocarbons, hydrocarbon derivatives. Nitrous oxide is not included. I understand, though, it's the statement is includes but not limited to. But nitrous oxide is not a chemical agent because it does not contain a toxic chemical or organic solvent. And if I could,
You realize nitrous oxide is toxic to humans?
it's used at dentist offices. It's not toxic to humans. It's a compound, but it's not a chemical agent as defined by the statute. And I think the fact that another part of that same section, 752.272A, prohibits people from selling. Here's the statute. Part 1. Persons shall not sell or distribute a device that solely contains nitrous oxide to a person under the age of 18 for any purpose. It prohibits people from selling these things to minors. But nowhere in the statute does, when this statute specifically is directed at nitrous oxide, nowhere does it prohibit the adult use of nitrous oxide. And so when a statute directly addresses something like this particular substance, but does not prohibit the use or possession by adults, then I believe the statutory can't.
So what do we do with dust off?
What do we, I'm sorry?
Yeah, I mean, as an adult, I can go in and I can buy dust off all day and night long to the extent I can find it.
Yeah. It's not.
but not a minor.
That's what the statutes are focused on. And I think because there is no statute that prohibits the use or possession of nitrous oxide by an adult, then
It's the chemical agent. It is not. Go ahead.
it's presumably legal, especially when there is a statute that is directly focused on the sale and distribution of nitrous oxide as illegal to minors. But why wouldn't it mention anything about the possession or use by adults? Because it's not a chemical agent.
No.
That's my argument, Your Honor.
Yeah, I hear it. I don't know that that's an argument, but that your logic is incredible to me.
Well, let me just finalize this by saying the reason the two officers arrested, as was testified to, Mr. Davis, they wanted to stand him up and arrest him for possession of drug paraphernalia. He was cited for that. That was dismissed. That's in the court record. And the dismissal order indicates because it's not illegal.
So, Mr. Farfelsky, let me ask you a question. Let's presume in one of the 9th rounds that you're correct regarding nitrous oxide. When the officers come to investigate, ask him to stand up, or asking to identify and just investigate what they may perceive as a crime. And I think the case law is rather clear. When they're investigating, even if incorrect, that doesn't make the command or what they ask unlawful. So at that point, while they're investigating, are you indicating to this court that the offense of, first of all, grabbing Officer Gonzalez, again, not complying with Officer Anderson, and then charging at Officer Gonzalez doesn't fall under the statute of resisting and obstructing?
Well, Your Honor, the case law on this element of...
Are you arguing that?
I'm arguing that because this element of resisting also implicates Fourth Amendment search and seizures issues. And that's straight out of People versus Morosky, 2023 case.
If the officer is briefly detaining someone to investigate the potential of a crime, gets charged at, are you saying it doesn't fall under this statute? Yes or no?
Yes, because the police precipitated a situation that did not have to occur. That prior to getting the police officers getting physical, making physical contact with Mr. Davis, he was minding his own business. And it wasn't until they laid hands on him, tried to physically seize his person, detain him, and then pull out tasers, that I would argue he had the right to resist an unlawful arrest, because at that point...
He had the right to charge as that Pittsfield officer. Is that what you're telling me?
I'm not saying that. But
is that what you're telling me?
Protect himself from a taser.
Please finish your argument.
That's it, Your Honor. I would object to bind over for those reasons.
Anything from the people?
I believe the court has the power to add charges that it seems fit. If the court wants to find over on additional charges, the people have no objection to that.
Court has listened to the testimony in this case of Officer Anderson. Officer Anderson is called or is dispatched to the location as a result of a citizen's complaint. You can hear the individual say what is going on. The officer goes over, sees that. I do not believe by any stretch of the imagination under the circumstances of that use of nitrous oxide that does not fall under the statute of 752.272. He's inhaling it. You can actually see him on the video inhaling it. The officer tells him to stop. The officer, even if at that point, if the officer's incorrect as to what it is, while the officer's investigating that, the officer is giving a lawful command so that he can fulfill his obligation to investigate what's going on. Officer Gonzalez arrives. What is then further clear is that they get him up. He then charges at Officer Gonzalez. They have to take him down and they have to tase him. I don't know under what argument that the defense says it's okay while an officer's even just minimally investigating the potential of a crime, that officer can be charged at and physical contact made with that officer. If you show me some case law that indicates that, then I won't bind over. But you don't have it because that's not the law. Plain and simple. People have indeed sustained their burden of showing that the defendant has committed the offense of resisting and obstructing police officer and first responder on count one, that being as to the resisting and obstructing as to Officer Gonzalez, the 2-year felony. The court is going to add an additional charge of resisting and obstructing a first responder for his conduct as it relates also to Officer Anderson, as the court believes that all of the commands that are given by Officer Anderson, while initially going there, and then as he is further giving commands to him at the time that after he, and I'm plain spoken, at the time that he attacked Officer Gonzalez, all of those lawful commands he did not abide by at all and did not comply with. And so the court believes that an added count 2 of assaulting and obstructing a first responder police officer is proper. The defendant is bound over to stand trial on counts 1 as pled and count 2.
Your Honor, as to arraignment, waive formal reading and stand mute to both charges.
Waive formal reading, standing mute. Court will enter a not guilty plea. Pre-trial in this matter will be set for
30 with Judge Slate.
We may have to arrange that date. As to bond in this case, I'm going to be honest with you. I do not. This person poses a risk to the public. I see a lot of resisting and obstructing cases. It is rare, very rare, that as the officers engage with the person, that you see somebody charge an officer and then not comply, to the point that these officers then have to deploy their tasers. And had they not, quite frankly, as he's coming at Officer Gonzalez, I don't believe he would have stopped. So you tell me why this person isn't a danger to the public, and I don't know why he has a PR, quite frankly.
Your Honor, I don't believe my client has any prior convictions. I know that he is in close contact and supported by his family. I've spoken to his mother. While he's been on the current bond, he's had no issues whatsoever at all, always appearing. I believe he's testing at community corrections, and I don't believe there's been any issues. So I don't see that there's anything that has changed, given the fact that he's been absolutely compliant with the court's bond orders.
There's anything from the people, I really don't need it, but
I would note that the people's original request did not include a monetary component. The original request was just for a conditional release, that being with some alcohol and substance abuse testing. I know that he doesn't have any prior criminal history. Ultimately, based on what the court heard today, if the court thinks that a monetary component is appropriate, I'm not going to object to that. I will leave it ultimately to the court's discretion.
Anything else?
As far as that, Your Honor, my client, I believe, works at a coffee shop. Or doesn't currently have a job. He was terminated a couple of days ago, but he wasn't making much money. He doesn't have much in the way of resources for a cash bond. And again, he's been absolutely compliant. There's been no safety issues in the community or with this court or anybody else.
If you run at an officer in the fashion that he did, he is a risk to the public. Bond is setting him out of $15,000 cash surety. Defendant is remanded. Give me an in custody date. Pardon? The date is still the same. August what? August 6th, 2026, 9 a.m. before Judge Slay. Thank you.
Just let that simmer for a moment. Do not presume that you can go to Ann Arbor, Michigan, get high on Whipits, and charge at the local constabulary and face off with Judge Simpson. It ain't gonna turn out well. As a matter of fact, just think about this, ladies and gentlemen. Don't get into arguments with police officers, even if they are wrong and they have no cause to arrest you. Just let them arrest you. Arguing with them on the side of the street or in the parking lot or whatever is not the time and place. Do not resist. Do not obstruct. Go to jail. The time to argue it is at court with your lawyer when you can prove that you're right with a sound mind. But you're not going to do it if they have you on camera huffing Whipits and charging officers. That's just not going to happen. Oh my dear God. Ladies and gentlemen, it's been a long night. We started things off with a little bit of Judge Cooper and that civil action stuff. That I love the civil action stuff. I'm sorry. I know it's kind of boring to some people, but I love it. I think it's very educational. It's the type of thing that we can all identify with. Those are the exact types of cases that you're not allowed to have a lawyer for. So it's good to see the pitfalls that other people go through in those types of situations. I am your lone wolf Usul, and I put these little things together every single night of the week. We'll be doing the same thing tomorrow. Same wolf time, same wolf channel. And don't go anywhere because we are redirecting over to our friend Hutch's channel, Sovereign Citizen Encounters. Thank you, Scott McIntosh, Stephen Sith Lord, and here, always. Thank you, Marty Duvall, also Northwest. Did I get Wendy Greek in there? I don't think I got Wendy Greek in there. She's always being very kind to the channel. Thank you all so very much. It is because of donations from viewers like you, this channel can do what it do. We appreciate you. Oh God, look at Patrick. Thank you so much, Patrick, for that gold coin. K-Far, thank you for showing up tonight. Enjoyed watching the playthrough of the video game a little bit earlier. That was kind of interesting. And yeah. Like the chat says, don't be stupid. It's not right. Thank you all so very much for coming out and hanging out with me. John Quattlebaum, you haven't shown up for, I think you've been here a couple of times. Thank you for coming back by. Charlene, it's great to see you again. Bat Boy is back. Yeah. And I'm me. I am your lone wolf Usul. I'm the guy who watches all these court cases, makes these reports, and finds all these interesting little clips for us to watch. And we got a lot more. Got a lot more that we'll be watching over the weekend too. Stuff that was cut from today. We'll talk about it later. For now, I'm your lone wolf Usul, and I am out. Maui. Marriage is what brings us together. Now go watch Hutch. Bye.